All right. Good afternoon, everybody. Scott Sternberg here at Sternberg, Naccari and White with my partner, Justin Alsterberg, managing partner of litigation. Glad to see you all again at noon on a Wednesday for our Wednesday web chat. Today, we're going to be talking about insurance claims, do's and don'ts. We've got hurricane season upcoming. Maybe you've had a claim related to the previous tropical weather that we've seen. Maybe you're making a claim related to COVID on some specialty policy. Whatever kind of policy you have, Justin's here to talk about how to make that claim. So go ahead and put your questions online live on Facebook, and I'm going to go ahead and throw it over to Justin. Justin?
Thank you, Scott. Yeah, we thought this was a really great time to do this with hurricane season just starting, and luckily we didn't have a hurricane, although we had or even a tropical storm. We had a rain much worse 2 days after, but I think it was a good time because it puts things on people's minds. But the purpose of today's presentation is not just to talk about hurricane claims, because a lot of the things we're going to be talking about today cover all of the claims on all your policies. And so we're going to get into those details and kind of give you a good do's and don'ts, 40,000 foot overview of how you should be handling these processes. Okay. So. Okay. As always, we have to give our little disclaimer. This presentation is for informational purposes only. It's not intended to be financial advice or to create any attorney-client relationship. And you should always consider consulting in any business or insurance decisions, financial advisor, or an attorney before making very important decisions. As always, you can get more information on our firm at www.SNW.LAW. There's three key terms that many of you may not be familiar with because they're legal terms, but they're going to be very important that I'm going to cover today with respect to making claims on your insurance policies. And just to be clear, when I'm saying your insurance policies, I mean an insurance policy that you have purchased, whether it be for your business, whether it be for your home or your condo, even in certain aspects of your auto insurance policy. The three key terms to remember, kind of stick in your brain in the claims process that I'm going to cover today, are the duty of good faith and fair dealing, which is something that your insurance company owes to you under Louisiana law. Satisfactory proof of loss, which is a very, very key and important term when you're making your insurance claims. And then bad faith penalties, which are available to you against the insurance company if they breach their duty of good faith and fair dealing after you provide them satisfactory proof of loss. So that's what we're going to go over today in a little more detail so you have a better understanding, because in my experience, these are concepts that a lot of people do not understand about their insurance in the claims making process. So, going into the do's and don'ts. When you or your business has sustained a loss and you're making a claim, most people, I'm just going to call my insurance company, I'm just going to call my agent, make the claim, and they're going to take care of it. That it is not that simple, especially if you want to fully protect your rights and maximize your claim. What you need to provide to your insurance company is satisfactory proof of loss. You also need to be cognizant. Every insurance policy requires you to cooperate and provide any information they request. However, just because they're requesting information does not necessarily mean that there's a situation where they cannot adjust and pay on your claim, even if you haven't given them every piece of information they want. And that's also something that we're going to cover today. Finally, you always need to remember your insurance company, under the law, they owe certain duties to you, okay, because you purchased a policy of insurance through them, whether it's for you personally or for your business. And those duties are specifically provided by Louisiana law. These duties that are owed, again, I've covered this a little bit already, they're applicable with any policy of insurance that you've bought, whether it's for you or your business. Your homeowner's policy, property or business interruption coverage for your business, One area in which people forget about a lot is the uninsured or underinsured motorist coverage on their auto policy, as well as the property coverage on your auto policy. Now, I do have to note the rules and times frames for property coverage on your auto policy if you're in an accident are a little bit different than the rest of the remaining type of claims, but the general concepts are the same in terms of proof of loss, and there being certain time frames in which the insurance company has to do things for you to satisfy its duties of good faith and fair dealing to you as a policyholder. Those specific duties are set forth by Louisiana insurance law. I don't need to go into all the specific legal terminology, but there's a specific statute that says your insurance policy owes you a duty of good faith and fair dealing. What does that exactly mean? They've got to treat you fairly. They have to treat you fairly throughout the claims process. Specific examples outside the claims process, and sometimes within, they can't misrepresent certain policy provisions. They also, we're not covering this today, but they can't cancel your policy of insurance without following certain things that the law provides for, okay? But with respect to the claims process, this leads us to our next key term, satisfactory proof of loss. This is what you have to provide the insurance company so you can fully protect yourself under the law in case you run into problems with the claims process. What's the biggest problem in the claims process? The insurance company valuing your claim for less, and oftentimes significantly less, than you think what your claim should be valued at. Very importantly, under the law, there is not a specific form that satisfactory proof of loss needs to be in. All that is required is the insurance company obtains enough information to be fully apprised of the value of your loss. I bring this up because insurance companies will have their own forms or their own requirements, and they will try to tell you, we need X, Y, and Z, or you did not fill out this specific form, and all those things to drag out your claim. That is not valid under the law. If you have given them enough information to fully apprise them of what your claim is, what the value of the claim is, that constitutes satisfactory proof of loss. And the reason that is simple. It's because it would be too onerous under the law if courts had to sift through all the different forms and all the different insurance companies. And it goes back to their duty of good faith and fair dealing. The law wants it to be simple. Look, you have provided the information. Now the insurance company needs to uphold its duties of good faith to you and properly adjust and pay on your claim. And this is one area where I see people and businesses that get into the most trouble or have their claims delayed or paid out low, and then they're consulting with us as attorneys because they haven't provided enough information, or, as I talked about earlier, they just simply called their agent, called their insurance company, and said they're going to handle it. If you let them handle it, you're taking it out of your hands, and that also gives the insurance company an out once you're in a dispute about the claim and the value of the claim. So what should you do? These are the do's in providing satisfactory proof of loss. Document, document, document. A paper trail is crucial, including specifically what information you provide to the insurance company on a specific date. You also need to provide your own estimates or damage figures. If it's a property claim, for example, say your home or business has a fire, you need to provide an estimate for the cost to repair your home or business. But you also need to provide, to the best that you can, a listing of contents that you had and their approximate value. For business losses, you need to get with your CPA, or you need to open up your QuickBooks, and you need to provide records that show how much business you have lost. And you need to continually provide this information to your insurance company so they are on the hook. So they're consistently getting satisfactory proof of loss, which they have to respond to because of their duties. Again, crucial with the documentation. You need to confirm everything that happens in the claims process in writing. I always tell people, even if you make your initial call by phone, you get an email address. They always have specific claim email addresses. And even after a phone call, you send an email confirming the conversation and what was spoken. This is especially the case with when you're providing information on a loss. You want to ask your insurance company, what else do I need to provide you? And if they tell you nothing else, confirm that in writing. You want to have a paper trail for if and when the claims process goes awry. One thing I kind of want to mention right now, it's not listed here, but in terms of keeping a record of your insured property, where I say even if it is just photos, with hurricane season, one thing I advise people to do, especially if you have a little bit of time right now because you're not fully back to work for COVID, for your house, your business, take your phone, go in each room, take multiple photos of everything in each room. That way, at the very least, if you have a fire or you have wind damage or you have things where property is destroyed, you can recreate easily from looking at those photos. Oh, I had X, Y, and Z in this room. These are the things that were damaged, and put a record together. This is especially important for closets. A lot of people don't think about that. I couldn't tell you how many suits that I have or how many dress shirts, but if I have a fire, that adds up quickly. For the ladies listening, your expensive purses, your expensive shoes.
My expensive shoes.
Well, my expensive shoes too. Those things you might forget, you might not remember. You have photos of that, then you're able to put together a listing of the property that was damaged and the value of that property. If you haven't done so, I know it's a lot to do, but this is a time to do it. This is a time to do it so you have a snapshot on the record just in case you ever have to make a claim, whether it's because of a hurricane or a fire or any other type of loss. And that's going to help you get the documentation on your proof of loss to the insurance company quickly where they have to respond. The don'ts. I've already said this, but I keep repeating it because it's super important. It's where I see the most problems. You don't simply call your claim in to the insurance agent or directly to the insurance adjuster and then completely rely on the insurance company to adjust your loss. A lot of people don't understand how insurance companies make money or don't fully understand it. Insurance companies don't just make money on the risk of enough policies being written so that claims are not made on them. They take the money in all those premiums and they reinvest that money. The less they pay on claims, the more profits they have because the more they have to invest. And considering that most insurance companies are very large companies that either owe duties to their own shareholders, or even in the case of privately held insurance companies, they're all about the profit. More profits is by paying less on claims. That is why you cannot rely solely on them to adjust your loss. They will never, ever, without getting information from you, pay you what your claim is really worth. You also should not fail to keep track of the dates of each step of the claim process. This goes back to document. That's why I try to say confirm everything in writing. But even when you're having a phone call, keep a list, whether it's a note on your phone, diary, however you want to keep it. I spoke to so-and-so on this date. I sent email on this date. That's also why I can encourage the emails. So that way you have a paper trail to keep track of the dates, but the dates are very important. Lastly, you should never, ever take the word of what the insurance company tells you about what is covered or not covered on your claim as the gospel. A lot of the insurance adjusters, especially with how the insurance industry has been condensed, they work in multiple states. they could go from a Louisiana claim to a claim in Missouri to a claim in Washington. They can get confused. They could not be telling you exactly how your claim and your policy provides coverage because everything is different in every state. And so without a review, do not ever believe. If they tell you something's not covered, you need to verify that yourself. Why do we have to do this satisfactory proof of loss? It's to protect your interests. As I noted to you, the insurance company owes you duties of good faith and fair dealing, and the law mandates that because your insurance contract policy is a contract between you and the insurer. And there have been enough abuses in the claims process over the years that the insurance industry is regulated by every state. Here's the important part on the satisfactory proof of loss on all of these claims and why you need to document dates. Once the insurance company receives satisfactory proof of loss, at a minimum, they have 30 days to tender you a check on your claim. If not, they can be found in bad faith under the law. Tender, though, that does not mean settle. That does not mean they can force you to sign a release, although they may tell you that. Tender just means there has to be a check in the mail within 30 days. If there is no check postmarked within 30 days after satisfactory proof of loss, they're already at the minimum standard and threshold for being in bad faith under the law. When you receive a check, because the 30 days and even the other time periods means postmarked. Anytime you receive a check from your insurance company, save the envelope or take a photo of it so you can see the postmarked date. The minimum bad faith standard on most claims, and again, this is accepting property claims on your auto policy. The time frames are a little different. But the minimum, and it's why it scares insurance companies so much, is 50% of the total amount of the claim, plus you get your attorney's fees paid for. So, an interesting example of this, say your claim has a total value of $150,000. Say they initially tender you $50,000, but they don't do so within 30 days. Even though they paid you that, and then you have to fight them to get the additional $100,000, the penalties apply to the entire amount, not just what they paid after you either had to engage a lawyer, which if it goes that far, you usually will have already had to, but on the whole thing. And this is also something that people do not realize. Even though bad faith claims scare insurance companies, they don't scare them enough to always properly train their adjusters. And this is also an area that we've seen a lot more of because of the way the insurance industry has been condensed. A decade ago, most of the big insurance companies had local offices here in the New Orleans area with trained adjusters that were familiar with Louisiana and knew how to handle the state. A lot of them have been closed, the consolidation of costs, and that goes back to my earlier portion of this chat where I was talking about an adjuster handling Louisiana, Missouri, and Washington claims back to back to back. This causes them to make mistakes. If you've documented your claim right and they're making a mistake and then you end up in a real dispute, by providing them satisfactory proof of loss, you can maximize the value of your claim with the penalties and minimize the pain of having to hire an attorney to help you get the money you should have been paid all along. Finally, I want to note on satisfactory proof of loss, this is not a one-shot deal. An insurance company can send you an initial tender based on the information that you provided, but if you're still gathering information and providing different information, each portion of your claim, which can be argued constitutes satisfactory loss, triggers a new 30-day period. Okay? Perfect example is what I've put on here. Say you have a restaurant and you have a fire in your kitchen. You send them a estimate from your contractor or someone you've hired through us or another attorney as to what it's going to cost to rebuild the fire damage. That starts a 30-day clock on that portion of the claim. However, your business loss claim, you're going to have to get with your CPA. You don't know how long it's going to take to rebuild. Most times, you're not going to be able to get that information out right away. Say it's another 30 days, you're able to show them a month's loss of revenue. You submit that. That starts another 30-day clock on that portion of the loss. So it's not a one-shot deal. There obviously, because the law is complex, there's a lot of other complicated issues that can happen, but this provided the most general 40,000-foot overview of what you really need to do and be aware of to set yourself up to have as successful of a claims process as possible. There are much more complicated aspects related to misrepresentation of policy terms, whether or not you provided satisfactory proof of loss, whether or not, even if you did, for example, in a fire case, if there are questions that whether the fire was arson, that can change up the calculus. But what we talked about here today is the minimum you need to know to set yourself up to make the process as easy as possible, as well as, most importantly, to protect your rights in the event the insurance company is really trying to lowball you on your claim.
Justin, we had a question come in online about the quick check scenario. That when you hear on TV, before you accept a quick check with me, right, for a personal injury claim, but that's for any claim, right? That's good advice.
That is great advice.
Yeah.
And for any claim, especially on non-personal injury claims, kind of like with what I'm talking about here, because they'll often want to wave a quick check in your face, but they will always make you sign something releasing your claim. And that's why the 30-day time frame and the fact that a tender is owed and not a settlement is very important, because they'll wave it in your face. You'll think, oh, this is good money, and they'll push you to sign that release. If you sign that release, it's over. If you don't, because you don't have to, you make sure your rights are protected.
And here at this firm, we'll review your policy for free. The initial consultation is always free with us. So
That's
if you
correct.
have a question, you should call Justin Alsterberg or one of the litigators here at Sternberg, Naccari & White, so that we can go over your policy, talk to you about the settlement that you've been offered, just to make sure that you're not getting a bad deal.
Absolutely. And to make sure that you've done everything that you need to do that we've covered here today to make sure you are set up. I've had plenty of consultations where the client calls me or the potential client, and I go over it, I review the policy, and I say, hey, they did a pretty good job on this one, or, you know, if the client is concerned that the dollar figures are a little bit off, it's probably not worth it to litigate because they at least tendered time. But we see way many more where it's absolutely in your best interest. And we'll tell you after the free initial consult, hire us and we can help you.
Yeah, but if it's a good deal, we'll tell you if it's a good deal. And any good lawyer is going to tell you to take the deal if it's in your favor, right?
Especially if the insurance company has at least followed its duties such that we don't think we have a bad faith claim where we can get your attorney's fees back.
Because those bad faith claims can be really disastrous for the insurance companies.
Very disastrous. And that's why they're scared of them.
Right.
But again, not scared enough, in my opinion, from what I've seen, to always make them follow the rules.
The questions we had, and we're almost up on our time. Anything else to add, Justin?
No.
Okay.
That's pretty much everything.
We've got a PPP update on our website that Keith Naccari put up relating to the new extended time period to pay your PPP loans back. Everybody take a look at that. We'll be back next Wednesday with another Wednesday web chat that I think will probably shift back to COVID-19 relief. given that it's hurricane season and we just already had one tropical event, we wanted to make sure that we got this out there. If you missed the live webcast, we will be putting this on our website by the end of the day for everybody to take a look at. He's Justin, J.A. at SNW.LAW. I'm Scott at SNW.LAW. Check out all of our great content on Facebook and at SNW.LAW. We'll see you next week. Everybody wash your hands. Thanks.
Be safe.